My name is Kyle Ingram and I practice employment and civil rights law. In this video, I will take you through the basics of mediation in employment disputes and what you can do to prepare for your best settlement. First, the basics of mediation. Mediation occurs usually at the EEOC, the Equal Employment Opportunity Commission, or a similar state agency. Mediation is not about one side winning and one side losing. The mediator is not on any particular side. He is just there to try to facilitate an agreement between the parties. This is not a trial or a substantive hearing. This is not where somebody is going to decide who is right and who's wrong. It's just going to be your opportunity to say your piece and the employer's opportunity to say its piece. The best thing that you can do to prepare for a negotiation is to come in with a number in order to resolve the dispute favorably to you during a normal mediation. When you get to the room where the mediation starts, the mediator is going to sit one of the parties on one side of the big table and the other party is going to sit across the table from them. It's going to be face to face and the mediator is going to be in the middle, usually at the head of the table. At that point, the mediator is going to offer the employee the opportunity to speak first. Usually this is something that the employee takes 5-10 minutes on. Once the employee is done, the employer may respond to that. The mediator then usually will split the parties into different rooms to negotiate. And it will be sort of shuttle diplomacy where the mediator will come and talk to one side and then we'll talk to the other and we'll pass settlement demands and why the settlement demand of the other party is simply not good enough. In order to understand how you should prepare a settlement demand, you need to understand what your best alternative to a negotiated agreement is. This is referred to in the literature as a BATNA. The employer is going to base its offer to you on what it thinks is its best alternative to settling today. If it believes that there's no investigation and no litigation that's going to produce a negative outcome for it, it has no reason to try to settle today. That is the company's best alternative to a negotiated agreement. In order to understand where you as an employee should start in developing your BATNA, you need to look at two sides of things. One is the damages that you can recover if this goes to litigation and the likelihood of that success. The way that I like to think of it is as a probability. Your likelihood of success is a probability that you will be entitled to damages, and then multiplied by the amount of those damages is the value of your case. In an example here, A sues company B and has $100,000 in potential damages. That could be back pay, emotional damages, punitive damages. If A has a 60% possibility of winning if it goes to trial, right? Nobody has a 100% chance of winning. If you have a 60% chance of winning if you're going to trial, then the value of that case is $60,000. That's 60% of $100,000. That is a reasonable way of evaluating a case. So what happens if the complainant doesn't settle during the course of mediation? Well, the litigation or the investigation is going to continue. That could mean that new facts come about. If there are new facts that change the case value, such as an admission that somebody made a statement that was discriminatory, or if witnesses come forward and will support the plaintiff or complainant in what they're saying happened, then that's going to change the value of the case, because now it seems more likely that you're going to win. How do you improve your chances of success if you go into a mediation? Well, first off, you need to start out with realistic expectations. You can't ask for the moon and expect the employer to pay it. The employer is going to try to get out of this with less than the full damages that it would have if it went to trial. So if your full damages is $400,000, they're not going to be willing to pay $400,000. And it's certainly going to be unreasonable in that circumstance to ask for $1 million because they would never be responsible for that. An employee can increase the pressure on the employer to settle by getting facts into what would be the record. So for example, if an employee has a witness, a critical witness who is going to testify on his behalf, getting a statement made under oath that is admissible in court will show the defendant that you've already established some of the facts that you're going to need in order to be able to prevail at trial. Don't negotiate against yourself. That means if you make an offer, you need to get a counteroffer. If you offer something and then without prompting, you lower that offer, it seems like you are just willing to give away anything. That is a huge loss of face in an employment negotiation. And finally, you need to explore your alternatives. Money isn't the only way to settle a case. You can also get reinstated into an old job if they will have you back. You can also get other kinds of alternatives. If you do settle, you need to know some things about what will be contained in that settlement agreement. Usually, settlements are agreed to verbally, and then they're later written down so that everybody knows what the terms are and there's no confusion about it. When these agreements are written down, there's a lot of other terms that usually come with them. An NDA, or a non-disclosure agreement, is a fairly typical term to be included in a settlement agreement. Usually this means that the employee cannot talk about the amount of money that he is being given under the terms of the settlement agreement. Settlements are typically global, meaning that they are not piecemeal. An employer is going to want to settle all of the claims at once. Finally, there's the tax treatment of any settlement funds. An employee needs to know that certain parts of it, and possibly all of it, may be taxed. A lawyer can help before, during, and after a mediation. A lawyer can identify the legal claims that you have. You may not be aware of some of the legal claims. He can identify admissible evidence in support of those claims. So this would be being able to find witnesses, getting their statements written under oath. There's also the threat of legal action. One of the things that employers typically do is wait for the employee to bring an actual case in court, hoping that the plaintiff will either miss a deadline or will simply just not be able to bring it because he doesn't have the funds to be able to do so. During a mediation, a lawyer can be very helpful in presenting your evidence, being able to say, we have this documentation, we have these emails, these show the following, and can be very convincing on issues of law. For example, saying, this law covers this particular act. That usually is not something that is within the employee's knowledge. A lawyer can also help you formulate an offer and counteroffers. When you offer that first offer to the employer, it most likely will be rejected. They will counteroffer with something. And then the question is, where do you go from there? Where do you want to end up, and how do you get there? A lawyer can help you with that. Knowing when to wait and when to litigate can be critical. You may want to wait out poor offers from the defendant, from the employer. The way you do that is by not accepting their offer. Knowing when to do that and how you're going to get to the point where they're going to give you an offer that you will accept is something a lawyer can help you out with. After mediation, if there is a successful agreement, a lawyer can help you review that settlement agreement. He can help you negotiate these after agreement provisions that may be damaging, such as NDAs, global settlement pieces, other things that are going to be included that I haven't discussed here. And finally, you can draft or amend provisions to help protect you if you have special circumstances. And this is something that you can work out with a lawyer. Nothing that I've said here today is legal advice specifically for you. If you think that you've been the victim of discrimination, you should consult with an attorney who can talk to you about your case. Many attorneys will consult for free or for a very low cost, and you should definitely explore your options before you select an attorney. Again, my name is Kyle Ingram, and thank you for taking the time to listen to me talk about mediations in employment disputes.